SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the 19th lecture of our course on law of copyright, patent, trademark and other IP. We have already covered our discussion, we have finished our discussion on law of copyright, patent and trademark. The last two lectures, the present one and the last one, will be on other IP. I have selected 3 forms of intellectual property for these 2 sessions. This lecture, the 19th lecture, will be on protection of plant varieties and farmers' rights, and 20th lecture will be on geographical indications and industrial designs. These are 2 special forms of IP which find place in the TRIPS agreement also, and let us discuss this law on plant variety. Why it is important to discuss plant variety law? Because plant biotechnology, just like animal biotechnology, is becoming important in the field of pharmaceuticals as well as in the field of agriculture. And when plant biotechnology is becoming an important sector, there are valid concerns of developing nations, there are concerns of countries like India. The first is the effect of biotechnology on health and the environment, which is in discussion these days. What is the impact of biotechnology, whether it is plant biotechnology or animal biotechnology on health and the environment. And second, a very important concern is the concern related to ethics, morality and access to natural resources. So, with these concerns in mind, we raise a question which is an equity based question. We always argue that Western firms are pirating and patenting biological material and traditional knowledge from gene rich developing countries. It is a very clear divide that Western countries are rich in technology, whereas the developing countries are rich in natural resources, and we accuse Western firms of pirating and patenting biological material and the traditional knowledge belonging to developing world, that too without fair and equitable sharing of benefits. You are using my material as the starting material to create your technology, and when you commercialize your technology, when you commercialize your invention, you gain benefit out of it, you do not share the benefit with the contributors. You do not transfer the technology with the countries from where you obtained the starting material. There appears to be a conflict between 2 international documents. One is called TRIPS agreement, the other is called Convention on Biological Diversity. TRIPS agreement will prefer to declare that all natural resources are resources of mankind. And therefore, if natural resources, genetic resources lie in your country, that does not become a property owned by the sovereign, because these are resources common to all. This understanding led to misappropriation of these natural properties, natural assets by developed countries. Then in 1993, when Convention on Biological Diversity came, it changed the whole paradigm. It presented a new argument. It said that natural resources are under sovereign control, and if the natural resources are under sovereign control, nobody can have access to my natural resources unless you have my permission. And when I will grant you permission, I will first of all insist on some information which has to be supplied by you to the concerned country. Inform me as to what shall be the consequences of allowing the access. Only then the country will decide whether to allow access or not. Not only that, while allowing access, the country can also impose conditions of benefit sharing. So, the idea of ABS, excess benefit sharing, emerged with the conclusion of Convention on Biological Diversity, which finds place in your Biological Diversity Act 2002. So, there appears to be conflict between TRIPS agreement and Convention on Biological Diversity. We will talk more about it later on as we progress. So, why we are discussing about plant variety law? Because of increasing importance these days we are giving to plant biotechnology and the concerns which developing nations have in relation to the impact of plant biotechnology on effect on health, on environment, the issues of ethics, morality, access to natural resources and so on. Article 27 of TRIPS agreement talks about those things which are eligible for patent. It also provides list of those things which can be excluded from patenting. It says that member countries can exclude following things from patenting. An exclusion is for plants, animals, essentially biological processes, those processes which are considered as essentially biological. Microorganisms are not excluded, non-biological processes are not excluded, microbiological processes are not excluded, these are patentable subject matter. What is excluded in TRIPS article 27 3b? Plants are excluded, no patent may be given, animals are excluded, no patent may be given, essentially biological process may be excluded. That is not very important for me. The second part is more important for me. Article 27 3b further says that a variety of plant may be granted either patent protection or it may be granted a sui generis protection, or it may be granted a protection which is combination of the two systems, the patent system and a sui generis system. So, article 27 3b recognizes that some protection has to be given to new varieties of plant. By the fact that varieties of plant are recognized in article 27 3b of TRIPS agreement means it is a form of intellectual property. The second thing is, by the fact that the chapter on patent recognizes some kind of protection for new varieties of plant means that whatever mechanism we develop, even if we do not grant patent protection and we adopt the second option given to us, that is to protect plant varieties by way of a sui generis system, even if we adopt that, it has to by and large conform with the requirements of or objectives of patent law chapter. So, two things are clear. One, plant variety is a form of IP because it finds mention, it finds reference in TRIPS agreement. Two, plant variety should be given protection similar to patent regime. Why? Because it finds mention, it finds reference in the chapter on patent law. So, TRIPS gives you flexibility. It says grant patent protection or alternatively devise a new mechanism, a sui generis protection. Sui generis protection means a protection of its own kind. Countries are free to design their laws for protection of new varieties of plant. I already mentioned that whatever mechanism you devise must conform with the broad requirements of patent law, or you can have a combination of two, a sui generis system and patent. If patent law is not protecting plant variety, then a PBR system must be evolved. Plant breeders' rights system is required if plant variety is not protected under patent law. A PBR system is to be evolved. So, we understand what is there in article 27 3b. It gives flexibility in terms of protecting plant varieties. You can have patent protection, you can have sui generis protection, you can have combination of the two. And if you are not granting patent protection, you must have some PBR. But the important omission here is that TRIPS does not refer to any of the pre-existing models when it refers to a sui generis kind of protection. Let me take you back to what TRIPS says about copyright. TRIPS says all the provisions of Berne Convention shall be the law of TRIPS. Similarly, in relation to patent law, TRIPS says all the provisions of Paris Convention from 1 to 2 and 19 shall be the law of TRIPS. So, TRIPS in most of the cases refers to some existing model. But in this case, in case of protection of plant varieties, TRIPS does not refer to any of the pre-existing international conventions. And it is not that we did not have any international convention existing when TRIPS was being concluded. We had UPOV convention, UPOV 1978 was there, UPOV 1991 was there, Union for Protection of New Varieties of Plant, French acronym is there. This international document was very much there. The two variants of this document, 1978 and 1991 variant was there, but TRIPS did not refer to any of these. This is a significant point, because referring to this would have meant that we are compelled to follow whatever is written in one of these. So, we have a lot of flexibility in terms of deciding as to what shall be the mode of protection for new varieties of plant. Another important provision of TRIPS agreement is Article 39, which talks about protection of trade secrets. Trade secrets are to be protected in all the WTO countries. Why I am saying trade secret is important? Because you see, the breeders of new plant variety, new animal variety often keep the parental lines secret. We do not get to know about the parents of that hybrid variety. It is quite effective for hybrid plant varieties, because the subsequent seed, the seeds of next generation, do not reproduce the same desired characteristics. So, therefore, if you start examining the seed of the next generation, you won't get those characteristics. How will you determine what are the parental lines? So, therefore, this can be effectively kept secret in case of hybrid varieties, where the resulting seeds, the next generation seeds, do not possess those properties, those characteristics. Another provision which is relevant here, set of provisions, articles 7, 8 and article 70 clause 4 are important with respect to protection of plant varieties and Farmers' Rights Act. Article 7 I have already mentioned. In patent law also, article 7 is objectives of TRIPS. It says IP laws must not only promote innovation, IP laws must also promote dissemination. Article 8 of TRIPS agreement is principles. It says while modifying municipal law to make it TRIPS compliant, the member countries are allowed to take measures so as to protect public health issues, public interest, public health. These concerns may be taken care of by the municipal laws when these laws are to be amended to make the laws TRIPS compliant. This is the most important provision, article 70 clause 4, for the purposes of plant variety law. Article 70 clause 4 says that all the past practices and all the activities with respect to which substantial investment has already been made at the time when TRIPS was coming into force. Listen to me carefully. When TRIPS was coming into force, at that point of time, all the past activities and all the activities with respect to which substantial investment had already been made, these activities may be continued, although these activities may have become unlawful. So, even if the activities may have become unlawful, but if these are past practices, you may continue with these past practices in your country. That is what article 70 clause 4 says. What can be done? The liability can be reduced. Now, imagine a law comes which says that every time you have to sow seeds, you will have to purchase it from the breeder. In a country which has been traditionally allowing right to sow, resow, farm saved seeds, this new law makes right to resow an illegal activity. Resowing farm saved seeds become an illegal activity immediately when the law is passed that every time you will have to get the seed from the breeder. But I can continue allowing this illegal activity to be performed because it is a past practice, and that is what we have done in our chapter 6 on farmers' rights. We will talk more about it later on. In case of patent, we have discussed the criteria for patent includes novelty, non-obviousness, industrial applicability. These are very high standards and may not be met, may not be achieved with respect to plant varieties. In plant variety law, you have lower standards used. For example, a protectable variety must be distinct. It should not have been commercially used before. So therefore, what I am trying to say, mere discovery of any plant growing in wild is sufficient to claim protection under Protection of Plant Varieties Act, whereas this will not be protected under Patent Act. Why? Because it is just a discovery, mere a discovery. Section 3 lists all the things which are not considered as invention. Mere discovery is not patentable. However, in plant variety, in case of plant variety, mere discovery of plants growing in the wild should be granted protection. So these are some of the reasons why we consider a different law for the protection of plant varieties and why we think that patent is too much. It's providing a very high standard which can never be met by new varieties of plant. So we have understood the international context. We understand articles 7, 8, article 70 clause 4. I refer to article 39. The most important one is article 27 3b of TRIPS agreement, which says that some sui generis protection must be granted to new varieties of plant. Now coming to Indian law, let us talk about some background. You see, the first draft of Indian law was made in the year 1993. I will go back to 1967 when a seed review team constituted by Government of India observed that PBR system may have many advantages. In the long run, the PBR system would be desirable. PBR system, plant breeders' rights system, the sui generis protection which I was referring to. I mentioned that in the previous slide that in case you are not granting patent protection, then the other option is PBR option, plant breeders' rights system. The seed review team constituted by Government of India observed that PBR system have many advantages. In the long run, the PBR system would be desirable, particularly as a means of encouraging private research. You cannot completely rely on public funded research in the area of seeds. In the year 1991, Kasim committee gave its recommendations and recommended that we must have a law for protection of varieties of plant, and on the basis of that, the first draft was prepared in the year 1993, and the most significant inadequacy of the draft, was failure to articulate farmers' right as ownership right. Farmers may be considered as owner of their varieties. Farmers may be only considered as conservers of traditional varieties. Farmers may only be given the right to claim part of benefit which accrues to the inventor. There are many ways in which we can see how farmers' rights can be conceived. The biggest problem was farmer was not treated as breeder in this original draft, and therefore a new redrafted bill came in 2000, which was passed by the Parliament in the year 2001, and therefore we have this Protection of Plant Varieties and Farmers' Rights Act 2001, PPVFR Act 2001. I said the most important omission, inadequacy was that we did not have a clear provision on farmer as a breeder. Farmer's ownership right was not recognized. In the new law, farmer is treated as par with breeder. In the new law, we have a separate chapter on farmers' rights. So before anything, let us see what are the unique aspects of PPVFR Act 2001. Remember, TRIPS gives me flexibility. I can protect plant variety either through patent or through a PBR system, a sui generis law. A sui generis law means a law of its own kind. We have chosen the second option and we have made our own sui generis law, which is a very forward-looking law. We will understand once we finish this session. What are the unique aspects of this law? First, farmers are treated as breeders. This is the point I was referring to. If farmer is treated as breeder, farmer's variety will be given the same recognition as we give to breeders' varieties. And therefore, now farmer as owner of his variety is recognized. Farmer is not just conservers of some existing varieties. His role is not only in terms of preserving existing varieties. He is recognized as owner of his varieties. Second point, this act talks about protection of new varieties. That's not all. It also talks about protection of existing varieties, extant varieties. It also talks about protection of farmers' varieties. So, it is not just only protection of new varieties of plant that we are talking about. We will be talking about protection of new varieties, extant varieties, farmers' varieties. There is an important point here, GURT. This is called genetic use restriction technology. The genetic use restriction technology, which means use of terminator gene, which means the harvested crop, the part of which will be used as seed for the next generation, for the next year, for next crop season. If you use that seed, it will not regenerate and there will not be any crop, there will not be any yield. The reproductive abilities are terminated. Such terminator gene is not allowed to be registered. So, any variety which contains terminator gene, which terminates the ability of that plant to regenerate into a plant, any variety which contains genetic use restriction technology is disqualified from registration. This is a very important point, a very unique feature of your PPVFR Act 2001. So, farmer is treated as breeder. It does not only talk about protection of new varieties, you have extant varieties, farmers' varieties. The law disqualifies terminator gene, GURT technology from registration. You have a detailed disclosure requirement, we will talk about that in section 18. An application for registration of new variety of plant must disclose good number of things. We will talk about the disclosure requirements. Now, after CBD, if you recall, I mentioned this point in CBD, natural resources are under sovereign control. You cannot have access to my natural resources unless you take my consent. So, if a foreigner comes to India and wants to have access to the forest in Himalayan region, he cannot have direct unrestricted access. He will have to take permission of National Biodiversity Authority, NBA, which is established under Protection of Plant Varieties and Farmers' Rights Act. And while granting permission, the National Biodiversity Authority will impose conditions of benefit sharing. Similarly, under PPVFR Act, we have PPVFR Authority, which is also responsible for ensuring benefit sharing. So, if it is clear that you are making your invention, you are making your plant, you are making your product using biological material from India, then you are obliged to share part of your benefit with those who are responsible for conservation of that material in India. That is the concept of benefit sharing. We will talk more about it. The Act talks about establishment of National Gene Fund. All the money which comes to authority either through registration or through benefit sharing will be credited to National Gene Fund, and this money may be used for other activities including giving rewards to enterprising agriculturist farmers. Genome Savior Award is one such example. The Act also provides for compulsory license. I am sure you are familiar with this concept of compulsory license? I discussed this idea in patent law. A license which is not granted out of volition, it is a license which is granted by the government without taking consent of the original breeder. This is a unique feature, and the most important is chapter 6, a full chapter on farmers' rights. So these are the unique features of PPVFR Act. We will talk about all of these one by one. Farmer as breeder, protection of new varieties, extant varieties, farmers' varieties, disqualification of terminator gene, GURT is not registered. There is a detailed disclosure requirement. You have a mechanism of benefit sharing. National Gene Fund has been established. There is a mechanism of compulsory licensing, and farmers' rights chapter, a full chapter on farmers' rights. TRIPS agreement says that plant variety has to be protected either by patent or by an effective sui generis law. It does not only say that the law has to be sui generis. Sui generis means of its own kind. And we saw in the previous slide, there are many features which make it sui generis. These are unique features. But at the same time, TRIPS requires you to have an effective law. An effective law, how do you decide effectiveness of law? We can decide it on the basis of maybe institutional infrastructure. What kind of institutions have we established? Whether these institutions are efficiently working or not, that is something which I will take up if I get some time. I will mainly talk about the sui generis aspects. Why have we made this act, PPVFR Act? What is the purpose of this act? This act has been made to stimulate investment in R&D. This act will encourage you to invest more in R&D, in seed sector, in agricultural sector, and therefore it will lead to agricultural development. It will lead to growth of seed industry. The basis for protection of farmers' rights, FAO has recognized this basis. Food and Agricultural Organization has recognized this basis as to why should we protect farmers' rights. Contribution made in conserving, improving and making available plant genetic resources for the development of new varieties. This is the basis for protecting farmers' rights. Farmers have made tremendous contribution in conserving genetic resources, in improving those genetic resources, in making those plant genetic resources available for development of new varieties. Imagine if farmers stopped cultivating some variety some 2000 years ago, by now we would have completely lost it. There would have been no information left with us about that variety. So they have been continuously cultivating it. That itself is a significant contribution because they conserved the variety, they preserved it, they improved it, they made it available to scientists for development of new varieties. So with these objectives, we have enacted PPVFR Act. We thought that it will stimulate investment in R&D, we thought it will lead to agricultural development, growth in seed industry. With these objectives, we enacted PPVFR Act, and now let us see some of the definitions. The law is on plant variety. The first word is therefore variety, which we must define. Variety is a distinctive and stable plant grouping. It is a plant grouping, group of plants which is stable and which is distinctive. I will talk about these words. This plant grouping is to be found in a single botanical taxon of lowest known rank. In taxonomic classification in botany, you must have studied, those who have done science must have studied that you have taxonomic classification, variety, species, genus, family, that is how you move up. The lowest known rank in taxonomic classification, the lowest known rank is what? Species. At this lowest known level, you have a plant grouping. You have group of plants. At this lowest level, you have group of plants, and this group is distinctive, it is stable. It is distinctive, it is stable. That grouping is called plant variety. So, plant variety is plant grouping in a single botanical taxon of lowest known rank, which is distinctive and stable, and which is defined by characteristics. It is described by characteristics. This grouping is defined by characteristics which result from genotype, which result from given genotype. So, the characteristics we are referring to is resulting from a given genotype. Distinctive means it is distinct from any other grouping of the same species. So, it is different from any other grouping, distinctiveness. It is stable means on repeated propagation it does not lose its characteristic. We will understand these words more later on. Seed of a variety is included in the definition of variety. Extant variety, transgenic variety, farmer's variety, all are included in the definition of variety. Microorganisms are excluded. So, section 2 ZA defines the term variety. It means a distinctive and stable plant grouping in a single botanical taxon of lowest known rank, which is defined by the characteristics resulting from a given genotype, and it includes seed of a variety, extant variety, transgenic variety, and farmer's variety. What do we mean by these words which we have used? First is distinct. Distinct means it is distinguishable, it is distinguishable. That plant grouping is distinctive means it is distinguishable from any other grouping on the basis of at least one of the characteristics. That may be in terms of yield, that may be in terms of some other quality, maybe pest resistant quality, maybe water resistant quality, maybe in the form of maybe texture, maybe color. In terms of one of the essential characteristic, this plant grouping is different from all other plant groupings. Then it can be called as a distinct plant grouping. Second, stable. Stable means that variety, that plant grouping is considered as unit. It means it remains unchanged after repeated propagation. Next season, next generation, on repeated propagation, it does not lose its essential characteristics. So, first generation seeds, third generation seeds, there is no difference in terms of essential characteristics, means it is a unit. It is a stable plant grouping. Such stable, distinct plant grouping may be called as a plant variety. I said it includes extant variety. Extant variety has been defined in section 2J. Extant varieties are those varieties which are notified under Seed Act 1996, 1 point. Second point, a variety about which there is common knowledge. So, all the existing varieties about which we have common knowledge are extant varieties. Farmers varieties are also the varieties about which we have common knowledge. So, farmers varieties are also included in the definition of extant varieties. Any variety, any other variety which is in public domain is an extant variety. All the existing varieties which are there in public domain, maybe farmers varieties, maybe any variety notified under Seed Act 1966, all these are existing varieties. These are considered as, these are called as extant varieties. Farmer has been defined in section 2K. I am not talking about farmer's variety. We have understood the meaning of the term variety. Variety means distinct and stable plant grouping in single botanical taxon of lowest known rank. It is distinct because it is distinguishable from all other plant groupings. It is stable because it is considered as a unit. It includes extant variety, it includes transgenic, it includes farmer's variety, and so on. Who is a farmer? Section 2K defines the term farmer. Farmer is cultivator, conserver, preserver of wild species. He is cultivator, conserver, preserver of wild species. He is the one who adds value to wild species. He is the one who has domesticated many of the wild species. Because when I am saying he is the one who adds value to wild species means what? Value addition is done by selection of wild species, identification of useful properties of those wild species. So therefore, farmer is the cultivator, conserver, preserver of wild species, or one who adds value to wild species by way of selection and identification of useful properties. Farmer's variety means a variety which has been traditionally cultivated and evolved by the farmer in their fields. A variety which has been traditionally cultivated and evolved by the farmers in their fields. There are many varieties which are developed by the farmers on their fields, not by the scientists in their sophisticated labs. That is the beauty of this act. It treats farmers' varieties at par with breeders' varieties. Farmers' variety does not mean only those varieties which are developed or cultivated or evolved by the farmers. It also includes all the wild relatives or land race of a variety about which farmer possesses common knowledge. So, all of my varieties which I am cultivating are farmers' varieties. All the varieties which have been evolved by farmers are farmers' varieties, and all the wild relatives, the entire land race about which farmer has got common general knowledge, all are farmers' varieties. There is another term which you have in section 2I known as essentially derived variety. I do not want to emphasize too much on this point. Essentially derived variety means a variety which is essentially derived from some other variety. So, it is essentially derived from some other plant variety, and if it is essentially derived from some other plant variety, it will retain the essential characteristics of that other plant variety, because it is one of the definitions. So, therefore, I am referring to it. Otherwise, I do not want to emphasize too much of it, because it is not of much use according to me nowadays. Now, let us come to the criteria for registration. Section 15 of the Act talks about criteria for registration. You see, this is the word, this is what we use generally, N does. N stands for novelty, D is distinctiveness, U is uniformity, S is stability. Let us understand these 4 criteria one by one. Novelty, the variety must be new in order to get protection, in order to get registration, but it is not a requirement for extant variety, because extant varieties are existing varieties, these can't be new, and therefore it does not apply with respect to farmers' variety. Now, what do we mean by novelty? On the date of filing, and mind, this is not absolute novelty, it is commercial novelty with 1 year grace period. What does that mean? On the date of filing of the application, the propagating or harvested material of the variety has not been sold, disposed of with the consent of the breeder for the purpose of exploitation of such variety with 1 year grace period. So, if I am filing my application today, let us say 1st January 2024, then the propagating material of that variety should not have been sold before 1st January 2023, that is 1 year grace period has been given. So, within these 12 months, if the propagating material was sold, that would not defeat the claim of novelty. This is the commercial novelty which we have. The second word is distinctiveness. Distinctiveness means that the variety is distinguishable from all other varieties in terms of at least one essential characteristic. Third is uniformity. Uniformity means subject to expected variations, the variety is uniform in its essential characteristics. Every seed will produce same yield, every seed will produce same plant, the variety is uniform. But that does not mean that it will be identical yield. Subject to expected variations, by and large the variety is uniform in its essential characteristics. Stability I have already mentioned. Stability means if the variety is considered as a unit, the variety is considered stable if the essential characteristics remain unchanged after repeated propagation. Essential characteristic is the word which I have been using. Distinctiveness means your variety must be different from other varieties in terms of essential characteristics. Uniformity means essential characteristics of all the seeds remain same. Stability on repeated propagation, the essential characteristics do not change. What do we mean by essential characteristics? These are heritable traits, these are inherited. These are heritable traits of a plant variety, and these are determined by one or more genes. So, these are genetic traits, these are heritable traits, and these traits contribute to principal features of the variety, performance of the variety, yield value of the variety. So, all the heritable traits, genetic traits which contribute to principal features, performance, value of the plant variety, these are essential characteristics. That is how it has been defined in section 2H. Criteria for registration. Section 15(4) talks about non-registrable variety. It says that a new variety shall not be registered under this act unless it has a denomination. There should be a name given to that variety. And then it identifies what are the qualities of the denomination. A denomination is not registrable if it is not capable of identifying such variety. A denomination is not registrable if it only consists of figures. If it is liable to mislead or cause confusion concerning the characteristics, value, identity of such variety, identity of breeder, is not different from every denomination which designates a variety of the same botanical species, if the denomination is likely to deceive the public, cause confusion, if the denomination is likely to hurt the religious sentiments, if the denomination is prohibited under names, emblems and names Prevention of Improper Use Act 1950, if the denomination solely consists of geographical name, then that particular name, that particular denomination is not registrable. Section 29 talks about those technologies which are excluded, which are not registrable. The technology which affects public order, morality, any technology which will have effect on human health, plant health, human life, animal life, any technology which will prejudice the environment, or terminator gene, the genetic use restriction technology. These are the technologies which are not registrable under the Act. How do we conduct DUS testing, distinctiveness, uniformity and stability testing? I mentioned that the criteria for protection is DUS, N-DUS, novelty, distinctiveness, uniformity, stability. Novelty means commercial novelty, distinctiveness, distinctive in terms of essential characteristics. Uniformity means all the seeds, every plant should have uniform characteristics, essential characteristics. Stability means repeated propagation. In repeated propagation, even after repeated propagation, it will not, the essential characteristics will not change. How do we test it? We do field testing. We do field testing for these crops for at least 2 crop seasons on a minimum of 2 different locations. An application is to be filed, separate fees is to be conducted for testing distinctiveness, uniformity and stability. And if the usual tests fails, for conducting special test, additional fees will have to be paid because we conduct field testing. In America, it is only document only testing, so that is different situation. In India, we do field testing for at least 2 crop seasons and on a minimum of 2 locations. When I was talking about Sui generis elements, I referred to disclosure requirement, section 18 subsection 1 talks about disclosure requirement, what all must be disclosed along with the application for registration of a variety. Your application must clearly tell what is the denomination of your variety. You must give an affidavit that you have not used terminator gene genetic use restriction technology. You must provide complete passport data of parental lines from which the variety has been derived. Mention the geographical location in India from where the genetic material has been collected. Provide all the information relating to contribution, if any, made by farmers, any village community, any institution, any organization in breeding, evolving or developing your variety. You have to write who all have contributed the initial material. You have to give a brief description of novelty, distinctiveness, uniformity, stability. In case of farmer's variety, there is no requirement to give novelty details, there is no requirement to give a denomination, and there is no requirement to give details of parental lines. This is a unique feature of your law. Although we treat farmer at par with breeder, we are giving special treatment to farmers. These are the details which you have to provide along with your application. I said there is one full chapter on farmers' rights. Farmers' rights can be understood only once we understood farmers' rights under UPOV. Under UPOV Convention 1978, the right given to the breeder provides that prior authorization of breeder shall be required for any commercial activity which you want to do. So, if I am the breeder of a variety, you need my authorization if you want to use my variety for any commercial purposes. Now, the moment you are saying that permission is required if you want to use it for any commercial purposes means what? For non-commercial purposes, no permission is required. What I am trying to say, non-commercial uses of breeder's variety falls in an exemption called as farmer's exemption. So, whatever non-commercial uses farmers can do, for that you do not require authorization of the breeder, because breeder's authorization is required only for commercial activities. So, farmer's privilege, farmer's exemption, any act which does not amount to commercial act can be done without taking permission. What do farmers do? Farmers sow, resow, exchange, barter, farm saved seeds. All those activities are activities which may be called as other than commercial activities, for which you do not require authorization in UPOV 1978. So, farmer's exemption, farmer's privilege is very much implied in UPOV 1978, which is not the case in UPOV 1991, where for any activity you need to have the authorization of the breeder. So, farmer's privilege, farmer's exemption is not implied in 1991. So, if a country joins UPOV 1991, it must clearly identify farmer's privilege, farmer's exemption, because simply by joining 1991 UPOV, you do not recognize farmer's privilege. That is what I have mentioned here. Under UPOV 1978, farmers have the privilege to save, use, exchange seeds, but cannot sell it, because selling it would mean commercial activity, and for performing commercial activity you need authorization of breeder even in UPOV 1978. What do we mean by farmer's right? Farmer's right has been articulated by FAO Resolution 1989. Farmer's rights are rights arising from the past, present and future contributions of farmers in conserving, improving and making available plant genetic resources, particularly those in centers of genetic diversity. These rights are vested in the international community as trustees for present and future generations. Now, deriving some meaning from FAO resolution of 1989, we have enacted our chapter 6, which I have been saying is a full chapter on farmers' rights. Kindly go back to the farmers' exemption, the farmers' privilege, which I mentioned. Under UPOV 1978, you need to take authorization of breeder only when you are willing to do some commercial activity. So, therefore, farmers' privilege is implied, which is not the case in 1991. India is neither a party of these two. How we have included farmers' rights under Indian law? In chapter 6, there are many clauses, there are many rights. I will tell you all of these rights one after the other. The first is right to seed. Right to seed means to save, use, exchange or sell seeds in the same manner as was entitled to before PPVFR Act. I refer to clause articles 70, clause 4, in which I said that past practices may be continued. We have used that provision to continue our past practices. However, what we have done, the right to sell seed is restricted. You cannot sell seeds as branded seed. You cannot sell seeds in a packaged form labeled with registered name. So, breeders' seeds cannot be sold by a farmer as breeder seed, as a branded seed. In loose market, in open market, he can even sell those seeds. So, this is the first right to seed. The second right is right to register varieties. Farmers are treated at par with commercial breeders. They can also apply for IPR over their variety. The criteria is lower. Farmers do not have to establish novelty in their variety. Third is right to reward and recognition. The Act provides for establishment of National Gene Fund. Through this fund, those farmers who play a role in conservation and varietal development are recognized and rewarded. The next is right to information and compensation for crop failure. Under section 39 subsection 2, a breeder is obliged to inform farmers about expected performance of their registered variety. If the material fails to perform according to whatever breeder has conveyed, the farmer may claim compensation for crop failure. The next is right to compensation for undisclosed use of traditional varieties. In case where it is established that breeder has not disclosed the source of variety belonging to a particular community, compensation can be granted through the gene fund. The next is right to adequate availability of registered material. The breeder is obliged to provide the planting material to the farmers at a reasonable price, and if the breeder fails to provide the planting material to farmers at a reasonable price, compulsory license can be issued in the same manner as we have discussed it in the Patent Act. Next is right to free service. The Act exempts farmers from paying fees for registration of variety, for conducting of tests, for renewal of registration, for opposition, and for fees on all legal proceedings. Farmers are exempted from paying any fees. Next is protection from infringement in case of lack of awareness. It is a safeguard against innocent infringement by farmers. And the last one is right to benefit sharing, which is there in sections 41 and 26. So, these are the rights: right to seed, right to register varieties, right to reward and recognition, right to information and compensation for crop failure, right to compensation for undisclosed use of traditional varieties, right to adequate availability of registered material, right to free service, protection from infringement in case of lack of awareness, and right to benefit sharing. Breeders have the right, exclusive right to produce, sell, market, distribute, import or export the variety. These are the acts which only breeder can do, and anybody who wants to sell, produce, market, distribute, import breeder's variety will have to take permission. In relation to extant varieties, usually government is deemed to be the owner of all the extant varieties, and here you have the duration of protection: 18 years for trees and vines, 15 years for extant varieties, 15 years in other cases. So, these are rights of breeders which you have in section 28. I will briefly talk about benefit sharing. There is no provision of prior informed consent in this act. If somebody wants to access some resources from India, he is not required to take consent of any authority. But claims of benefit sharing can be made. But that claim of benefit sharing shall be made once the variety is registered. So, before the registration stage, there is no participation. Authority will publish the contents of registration, and authority will invite claims of benefit sharing. The claims of benefit sharing will be responded by the breeder. If the breeder fails to respond in 3 months, a decision will be taken. There are certain factors which will be taken into account by the authority when it decides the claim of benefit sharing. These are the factors which I have mentioned, and whatever the money is generated out of the process of benefit sharing will be deposited in National Gene Fund. We have a chapter, a full chapter 7 of the Act on Compulsory License. If you recall, the entire process by and large is similar to what we have studied in patent law. An application for compulsory license can be filed after 3 years from the date of grant. The grounds are reasonable requirements not being met. The grounds are the planting material, the propagating material is not available at a reasonable price. Here there is a difference. In patent law we talk about reasonably affordable price, whereas in plant variety law we only talk about reasonable price. If one of these two grounds exist, then the authority, after consultation with central government and after giving opportunity to the breeder to file opposition and after giving hearing, will pass an order to issue compulsory license on such terms and conditions as it deems fit. The factors are same as those which we have studied in patent law. Look at the nature of variety, look at the time elapsed since grant, look at the measures which the breeder has taken to meet the requirements of public, look at the capacity, ability and technical competence of the applicant. So therefore, what we have discussed in this session, we discussed the basic concepts of PPVFR Act 2001. As mentioned before, it is a sui generis law. I said I will be able to talk about effectiveness if I save some time. Effectiveness is to be judged from on the basis of working of the institutions. It has created institutional infrastructure which is responsible for proper implementation of this very forward looking act. It is truly an effective sui generis law as required by TRIPS agreement. In the next lecture, we will discuss the law on geographical indications and law on industrial designs. Thank you very much for joining. That's all I have for you on Protection of Plant Varieties and Farmers' Rights Act. Thank you very much.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.